There are many doubts in the minds of the people in the Crown Court today. Doubts as to whether Irene Rutland really stole a handbag. No one saw her. And if she intended to injure a policeman who was arresting her for something she denies she did. Although much of the evidence is circumstantial, the arm of coincidence can only stretch so far.
Are you completely recovered, Mrs. Rutland? I could adjourn the court.
No, thank you. I'm all right now.
Very well. Do you wish to resume your cross-examination, Mr. O'Connor?
I do, my lord.
Very well.
Mrs. Rutland, you told my learned friend that you'd had about 15 or 16 pounds in your bag when you went into the restaurant.
Yes.
That you only spent £7 during the previous day and up to that time on the 16th, in spite of your entertainment in 2 pubs.
Yes.
Had you not been shopping at all?
No, I always shop at the weekends for the whole week. I don't find time during the day. Except for the wine. I went out to get that at lunchtime. It was special.
Oh, yes. So we noticed. Chateau bottle.
What year, Mr. O'Connor?
66, my lord. Must have been a very special occasion to warrant a bottle of wine like that.
Yes, it was. I was giving dinner to someone.
But you didn't?
No.
Why not?
He wasn't able to come.
And when did you find out that he wouldn't be able to come?
After work at 6 o'clock.
How upsetting for you. A bad meeting, a row, and the man you'd invited to dinner stood you up. Enough to upset anyone, Mrs. Rutland, especially someone who's emotionally disturbed.
Oh, really?
You've stated that for the last 6 months you've been an outpatient at the psychiatric department of the county hospital.
Yes.
The most upsetting period of your life, Mrs. Rutland. 6 months. Now, you claim that Constable Mugridge arrested you after he'd sustained his injury.
Yes, that's right.
He says it was before.
I know.
Why do you dispute that?
Because it's not correct. Well, that's what we're here for, isn't it? To get things right?
Oh, yes, indeed, Mrs. Rutland. But I put it to you that the real reason that you are objecting and disputing the time at which you allege you were arrested is not because it's not correct, but because you realise it'll lead to the lesser charge.
Mr. O'Connor, I think it might be as well if I explained that aspect of the case to the jury.
I shall be obliged, my lord.
Now, you heard in the indictment of 4 charges, 2 of which were wounding charges. The first with intent to cause grievous bodily harm, and the second with intent to resist lawful apprehension, arrest. Now, if the defendant can prove that she was not told she was being arrested until after she had hit the policeman, she would naturally face the lesser charge. She could hardly be resisting an arrest that she didn't know was coming. I hope that clarifies the situation for you. Mr. O'Connor?
Thank you, my lord. Are you asking us to believe that you are not aware of this rather important demarcation?
I just want to get things right.
Mr. O'Connor, am I right in believing that neither of the other witnesses in the restaurant stated at what time during the proceedings the arrest was made?
Can't find as much in my notes, my lord.
I have been looking at my notes, my lord, and in fact no witness has testified to this.
If this is the case, they cannot do so now. An important point. Do you have any more questions, Mr. O'Connor?
No, my lord.
Do you wish to re-examine on any point, Mr. Lottery?
No, thank you, my lord.
Very well, then. You may leave the witness box.
My only other witness, my lord, is the defendant's employer. I call Mr. Brian Hodge. Mr. Hodge, what is your position with the firm?
Chairman and Managing Director.
How long have you known the defendant?
She's been with the firm 7 years, and I've known her well for the past 3.
What is your opinion of her as an employee?
She's conscientious, loyal, and very talented. Her work has always been of a high standard, whether in her present capacity as public relations officer or her former one.
Which was?
Secretary to the man who previously held the post. She applied for the job after he tendered his resignation, and I agreed to let her try it for 3 months. She proved herself, and I've never regretted my decision.
And now that was 3 years ago.
That is correct.
How is she looked upon by her colleagues?
with the utmost respect. She's very popular with the lower orders, too, which speaks for itself.
Indeed. What about her honesty?
That goes without saying.
Oh, we'd rather you did.
I would trust her with my life.
In her official capacity, she would, of course, have to do a certain amount of entertaining.
Of course.
On these occasions, how did she conduct herself?
Perfectly. She's good at her job. She knows when one entertains one's customers, it's not for one's own pleasure, but for what benefit can be achieved by it, whether custom or goodwill. An impression has to be made, and Mrs. Rutland has always made a very good one.
Now, no doubt a certain amount of drinking is involved.
She has a trick as far as that is concerned. At the beginning of a session, she orders a whiskey and dry ginger, and then keeps adding ginger, so she keeps on top of the situation while the others may be, well, sinking somewhat.
So you have never seen her the worse for drink?
Good Lord, no, never. She would never still be in my employ if I had.
Do you meet her socially?
I have done, yes.
There's nothing unusual in that.
Of course not. Ours is a friendly organization. We don't stand on ceremony.
She is still, of course, in your employ.
Of course, she's an invaluable member of my staff. I would be very sorry to lose her.
I hope you're not prejudging the outcome of this case, Mr. Hodge.
My lord, whatever happens here has no bearing on my opinion of Mrs. Rutland as employee. It is simply that she told me she wishes to emigrate to Canada in the near future. She has a married daughter living there, I believe.
Is this a recent decision?
Well, Mrs. Rutland's husband died 6 months ago, and her daughter is her only family now. Soon after Mr. Rutland died, the daughter suggested her mother should join her in Canada. I tried to dissuade her, but she felt she would be happier there. Of course, whether she will be accepted for emigration now depends on the outcome of this.
Mr. Hodge, thank you.
Mr. Hodge, have there been any changes in her behaviour since her husband died?
No. She was upset, of course, but she's coped with it well.
Thank you, Mr. Hodge.
Can I say something else?
If it is relevant to the case.
Well, I don't know really, but my colleagues and I regularly call in at the Carpenter's Arms for a drink, usually on Friday evenings. And as I say, I don't know if it is relevant, but I thought I'd mention there's someone in the court today I've often seen there.
Really? Would you identify him, please?
Not him, her. The young lady sitting over there.
Thank you, Mr. Hodge.
I suggest that you recall that witness, Mr. O'Connor.
Of course, my lord. If I may cross-examine this one first, though. You say you usually go to the Carpenter's Arms on a Friday.
That is correct.
Were you there on the Friday in question?
No.
Why not?
There'd been a meeting. It ended late, so I went straight home instead.
How late?
About 6:30, something like that.
Do you know if any of your colleagues went to the pub?
I don't think so. We all have homes to go to.
Mrs. Rutland hasn't.
Pardon?
She lives alone, doesn't she? There's nothing to prevent her going.
I believe she stayed behind working.
Do you know that?
She mentioned as much.
Yes, but do you know as much?
Yes. Well, she was still there at 6:30.
Did you speak to her?
Yes.
You say you went home.
Yes.
You're divorced, are you not?
Yes.
And you were on very good terms with the accused.
Yes. I was.
Still are?
Yes. Yes.
But on the day in question, would you tell the court how you felt about her then? Is it not true that the row mentioned earlier was in fact a direct conflict between yourself and the accused?
We had an argument, a discussion. Nothing more.
And it was you who was going to Mrs. Rutland's for dinner, for whom she bought an extremely expensive bottle of wine.
As a matter of fact, it was.
And you saw her, did you not, and cancelled dinner?
Yes, but I don't see...
I do, Mr. Hodge.
Was she upset by this?
Naturally. I suppose it might have upset her, but it wasn't that important.
Really? Mr. Hodge, why did you try, prior to this meeting, to dissuade Mrs. Rutland from going to Canada?
My firm, we didn't want to lose her.
Wouldn't it be more accurate to say that you didn't want to lose her? For your own personal reasons? For the same reasons as you painted such a perfect picture of her just a few minutes ago? Thank you, Mr. Hodge.
Very well, you may stand down.
Thank you, my lord.
I recall Miss Shirley Flint.
I would remind you that you are still on oath.
I tender the witness for cross-examination.
I am obliged. So, Miss Flint, you regularly frequent the Carpenter's Arms public house, do you?
Sometimes, not regular.
You heard Mr. Hodge saying he remembers seeing you there.
I said I go there sometimes.
Usually on a Friday?
Not particularly.
Well, Mr. Hodge only goes there on Fridays.
Well, he's lucky to catch me then, isn't he?
Extremely. You happened to be there on the Friday night in question?
I was working that night, wasn't I?
Well, I take it you work most nights.
Yeah.
And how did you manage to go to the pub at all?
Well, Spiros, he lets me come in later sometimes.
Oh, I see. So you would only be at the pub early in the evening?
When I do go, yes.
You could have done so on this particular Friday, could you not? Visited the Carpenter's Arms early in the evening, gone on to work at the Carrinia later, say at 8 o'clock.
I could have, but I didn't.
Didn't you, Miss Flint? Wasn't it you who removed the handbag from the pub?
No. No, I wouldn't.
Wouldn't you, Miss Flint?
No. I did go in early. Spiros will tell you I did.
Oh, I'm sure he would tell me. You could then be independent witnesses for each other, couldn't you? Thank you, Miss Flint, that's all.
Do you want to re-examine Mr. O'Connor?
No, my lord.
You may go.
My lord, in an attempt to clear this matter up, I would like to ask for the publican, Mr. Gorman, to be recalled.
Indeed.
I call John Gorman.
May I remind you, too, Mr. Gorman, that you are still on oath?
Yes, sir, thank you.
Mr. Gorman, you've heard Mr. Hodge say that he remembers seeing Miss Shirley Flint at the Carpenter's Arms. Now, you have seen Miss Flint in the witness box. Do you remember seeing her at your pub?
Yes.
Would you call her a regular customer?
Well, not regularly, exactly. She's been in quite a few times.
Enough times for you to recognize her here, anyway. Can you remember seeing her on the night of Friday, the 16th of November? The night when Miss Brightson lost her handbag?
No, I'm sorry, I can't. It's going back a while now.
And you said yourself it was very crowded that night.
Yes, it certainly was.
Even earlier on, I suppose.
Well, Fridays always are. It's hard to know who's there and who's not.
Indeed, Mr. Gorman. On Friday nights, it's hard to know who's there and who's not. Thank you very much.
Members of the jury, let us consider the facts of this case. First, the accused was at both the venues concerned. She admits that herself, and there are witnesses to prove it. Now, she says that she arrived at the Carpenter's Arms after the handbag had been stolen. But no one can support her story. Remember that she was usually there at 6:30 p.m. But on this night, on this single occasion, she says that she decided to go later, even though she has admitted she hated the noisy music. She knew her friends would not be there, and she knew of a quieter pub nearby. She cannot produce one witness to say that she was not there from 6:30 p.m. Now, I put it to you that she was at the Carpenter's Arms at the time that the handbag was stolen, which was later found in a restaurant under a table at which she was sitting. Can we be expected to believe such a coincidence? Consider the money involved. There were £15 missing from the recovered handbag, 2 £5 notes and 5 £1 notes. When Mrs. Rutland was searched at the police station, she had in her possession 2 £5 notes and 2 £1 notes. There was also 80p change. Now, the bill in the restaurant amounted to £2 and 30p. So prior to paying the bill, the accused had in her purse almost the exact amount that was missing from the handbag. Is this also a coincidence? Irene Rutland went into that restaurant as a last resort. We have established that she is under psychiatric care, depressed because of the death of her husband, and on the evening in question, considerably upset. Firstly, because of the criticism levelled at her by her employer, and then by his rejection of her invitation to dinner. She was an unbalanced and emotional woman. You yourselves saw how prejudiced she was against the type of restaurant it was and the kind of man that she considered the owner to be. The defendant has admitted to drinking what normal people would call an excessive amount of alcohol when she was asked to leave by the proprietor, which was his right. She lost her control completely. She lashed out at him, doing considerable damage to his property, and it was this behaviour which led to her attack on the police constable shortly afterwards. Now, while I have no wish to minimise the seriousness of the other charges in this case, the first two, the wounding charges, are the prime concern. Violence in any form is abhorrent in a civilised society, and even more loathsome when it is inflicted upon those officers who are there to uphold the law. This woman had already attacked the proprietor, so her assault on the police constable could not be excused as uncharacteristic or done on the spur of the moment. She had every reason to evade arrest. She had stolen a handbag. She had stolen a purse with money in it. She had wreaked havoc on an innocent man's property, and she was obviously drunk. Now, you've heard her employer's testimony. Are we really to believe it? Coloured as it is by his feelings towards her. Ladies and gentlemen, you see before you a woman who, quite frankly, should know better than to behave in this manner. Her personal difficulties are no excuse for the deplorable behaviour on this night. I put it to you that you have no alternative but to find her guilty on every count.
My lord. Members of the jury, I want you to take a good look at this lady who is accused of these absurd charges. This is Irene Rutland. And I want to ask you whether you can believe she is the hellion described by the prosecution. You've come to know Mrs. Rutland here in this court, and I'm confident that you will have assessed her character very much as I have, and as her employer, Mr. Hodge, has, and as her colleagues have at her place of work. And I'm confident that, like myself, you will be finding it impossible to believe Mrs. Rutland capable of the violent acts described by the prosecution. However, let us look at the prosecution's charges one by one and see if we can't show them up for the empty accusations they are. Now, my learned friend has suggested that Mrs. Rutland has lied about the time that she was in the Carpenter's Arms public house. Well, let's face it, she had no reason to admit she'd been there at all. She saw no one she knew, and as far as she was concerned, no one had seen her. So she could have denied being there at all and saved herself a lot of bother, but that is not Mrs. Rutland's way. She has promised to tell the truth here in this court, and that is what she has done. Now, the publican has said he saw her that evening, but he couldn't pinpoint the actual time. Indeed, when I asked him whether he'd seen the restaurant waitress, Miss Shirley Flint, in his pub that night, he said that on a Friday night it's hard to know who's there and who's not. So can we expect him to remember a particular Friday night in November of last year? Well, let's look at Shirley Flint's evidence. She grudgingly admitted that she does go to that particular pub on Fridays, and, significantly enough, you may think, it was she who discovered Miss Brightson's lost handbag leaning up against the leg of the table at which Mrs. Rutland had been sitting, and which, according to other prosecution evidence, had by this time fallen over. It's a most remarkable handbag, this, to remain propped up against the leg of an upturned table. I submit, ladies and gentlemen, that it is just as likely that Miss Flint stole that handbag as that my client was responsible. Indeed, you may think more likely. However, be that as it may, at no time was that handbag seen in the defendant's possession. At no time. Well, I don't think we need dwell on the evidence of Mr. Platanos, the restaurant owner. It is, I am sure, sufficiently clear to you that his evidence, like that of his girl, Miss Flint, is, to put it mildly, somewhat biased. As to the money involved, the prosecution has compared the amount missing from the stolen handbag with that found on Mrs. Rutland when she was searched at the police station. But what's there to compare? No matched numbers. Indeed, members of the jury, if you were to look at your own wallets, your own handbags, you would most likely find the same sort of notes in your possession. And you've all seen Mrs. Rutland's bank statement, which indicates quite clearly that she withdrew £18 on that particular day. Well, now let's consider the claim of the young police constable that Mrs. Rutland deliberately assaulted him. Now, why should she do this? It's been established that she was going willingly to the police station with him before the incident occurred. Why should she suddenly turn on him like a cornered animal, savagely beating him across the face? I mean, is it at all likely? No, members of the jury, however much we quite rightly sympathise with the young constable for his painful injury, it is obvious that it was an unfortunate accident. As for attempting to resist her lawful apprehension, well, the door was unlocked, and yet my client made no attempt to run away. No, she was much more concerned for the young policeman to whom she was administering help. An act hardly in accordance with the picture my learned friend had sought to paint of a violent, disturbed drunkard. Ladies and gentlemen, my client's greatest wish, indeed her only hope for happiness, she feels, is to rejoin her daughter and son-in-law in Canada. Well, members of the jury, that depends upon your verdict here today. And with the overwhelming doubts that I'm sure are in all your minds, your verdict can only be not guilty on all counts.
Now, although compassion is allowed, and indeed it is encouraged in these courts, it must be employed after you have made up your minds as to the guilt or innocence of the accused, and not before. It must be based upon the evidence as it's laid before you and your assessment of it. What happens after the outcome of this trial is of no interest to you, and you must erase from your minds any consideration that may have wrongly been implanted there by the defence. Now, I've explained, I think, the demarcation of the two wounding charges, but you still might be confused about the verdicts that you may bring in. Now, if you think Mrs. Rutland did not intend to evade arrest, you must dismiss that charge against her, but still consider the first charge, wounding with intent to cause grievous bodily harm. And in that case, you must make up your minds whether or not she intended to injure the constable. Now, if you find or you think that Mrs. Rutland was trying to evade arrest and find her guilty, you must still consider the grievous bodily harm charge. They are not alternatives. Now, the other two charges, I think, are quite straightforward and need no further exposition from me. But remember, it is for the prosecution to prove its case beyond reasonable doubt. And should you think that there was a reasonable doubt about any one of the four charges, then it would be your duty to return a verdict of not guilty on that charge. Now, members of the jury, I will ask you to retire to consider your verdict.
All stand.
Just answer this question, yes or no. Have you reached verdicts upon which you are all agreed?
Yes.
On the first count, do you find the defendant Irene Mary Rutland guilty or not guilty of wounding with intent to do grievous bodily harm?
Not guilty.
On the second count, guilty or not guilty of wounding with intent to resist her lawful apprehension?
Guilty.
Is that the verdict of you all?
Yes.
On the third count, guilty or not guilty of the theft of a handbag and £15?
Not guilty.
On the fourth count, guilty or not guilty of damage to property?
Guilty.
Is that the verdict of you all?
Yes.
Mr. Justice Campbell sentenced Irene Rutland to 18 months suspended prison sentence for wounding with intent to evade her lawful apprehension, and a fine of £40 for damage to property, plus £28.40 restitution. Next week, a chance to join the jury in assessing another case in the Crown Court.